Welcome to The Explainer. So, picture this. A crime gets reported, but it happened maybe 20, 30 years ago. Witnesses are gone, evidence has vanished, and memories, well, they're faded at best. How on earth can our justice system deliver a fair outcome for anyone? Today, we're digging into that exact challenge, the search for justice when the past is pretty much all you have to go on.
Okay, let's dive right into the heart of this. It's a fundamental dilemma, isn't it? On one hand, you've got the absolute right of a complainant to seek justice, and that right shouldn't have an expiry date. But on the other hand, you have the right of an accused person to a fair trial. So how does a court balance those two things, the right to be heard versus the right to a fair defense, especially when the crucial tools for that defense, things like memories, alibis, and witnesses, have been all but erased by time?
So here's our roadmap for this explainer. We're going to start with the core problem itself, the delay. Then we'll look at the original solution the courts came up with, this thing called the Longman warning, and figure out why it was eventually replaced. We'll even see how different states are tackling this problem today, before we pull it all together to really understand the incredible balancing act that this whole thing requires.
Right, so the main issue here is something lawyers call forensic disadvantage. And it's exactly what it sounds like. I mean, think about it from the defendant's point of view. Where were you on a random Tuesday night 15 years ago? Could you prove it? Maybe the one person who could back you up has moved away or even passed on. That credit card receipt that could prove your alibi, it's long gone. That is forensic disadvantage, the real, practical inability to challenge an accusation because time has just wiped the slate clean.
For decades, the courts didn't actually wait around for politicians to solve this problem. They went ahead and created their own powerful tool, a very specific instruction for juries developed by judges themselves. It became known as the Longman warning.
And listen, this was not just some gentle suggestion. It was a mandate. In cases where there was a really significant delay, the judge was required to give this warning. It was a formal, deadly serious instruction to the jury about the potential dangers of relying on old, untested evidence, and it carried the full weight and authority of the court.
You know, this warning was a fascinating judicial tightrope walk. The judge basically had to tell the jury two things that sound almost contradictory. First, because of the delay, it was dangerous to convict. But then, in the very next breath, they had to add that the jury could still convict, but only if they scrutinized the evidence with great care. So it was a message of extreme caution, but it wasn't an outright ban on convicting.
This phrase right here, dangerous to convict, was the absolute soul of the Longman warning. It was a massive red flag for the jury. But its power was also its biggest problem. Critics started to argue that it put way too much emphasis on the danger of convicting, that it might overshadow the complainant's evidence and make it nearly impossible to get a conviction, no matter how strong the case felt. And that controversy, well, it led to a huge change.
So, with that controversy brewing, governments decided the rules needed a major overhaul. Parliament stepped in to replace the old judge-made warning with new, standardized laws. This move effectively took the power to create these rules out of the hands of the courts and put it into the hands of legislators.
And this shift is just fundamental. The focus moved away from a general, vague feeling of danger just because time had passed. Now the defense has to prove a significant forensic disadvantage, a specific, concrete harm to their case. It's no longer enough to just say, hey, a lot of time has gone by. They have to show exactly how that passage of time has actively damaged their ability to fight the allegation.
I mean, just look at this contrast. It's incredible. The old way, the Longman warning, required the judge to say it was dangerous to convict. The new way, the statutory rules, explicitly forbid it. This is a total 180-degree turn in legal thinking, moving from a mandatory generalized warning to a conditional one that's only triggered by proven specific harm.
But getting rid of the old rule was really just the first step. Not every state in Australia agreed on what the exact replacement should be. And this is where it gets even more nuanced because different places have put their own unique spin on the new rules.
The differences here are subtle, but they are so crucial. For instance, New South Wales actually gives a list of examples of what counts as a disadvantage. Victoria goes even further and tells judges they can't even use the old phrase, scrutinize with great care. In South Australia, it's the most extreme. It scraps the word warning altogether, replacing it with a more neutral explanation. It's a really fascinating glimpse into how different legal systems are all trying to wrestle with the very same problem.
Now, you might be thinking, okay, that's already pretty complicated. But for a judge directing a jury in one of these trials, the whole issue of delay is just one of many, many potential hurdles they have to clear.
Just look at this checklist. All of these names, Murray, Crofts, Jip, they all represent other very specific, very complex warnings a judge might have to give a jury in a single trial. We don't need to know what each one means. The big point is that the warning about delay is just one piece of an incredibly complicated puzzle. Getting any one of these instructions even slightly wrong can derail the entire trial. It's an absolute legal minefield.
So what's the big takeaway from all this? Why have the laws changed in this way, and what does it all mean for the idea of justice?
Ultimately, this whole story is about one thing: a single, never-ending balancing act. On one side of the scale, you have one of the most bedrock principles of our legal system, the right of an accused person to a fair trial. But on the other side, you have the equally vital need to make sure there's a path to justice for complainants, no matter how much time has passed. The law is just constantly being fine-tuned, tweaked, and adjusted, always trying to find that perfect center.
And that leaves us with the core unanswered question. In this search for justice, how do you perfectly balance the fairness required in the present with the fading, sometimes distorted echo of the past? There are no easy answers here, and finding that balance, well, it remains one of the most difficult and profound challenges our justice system will ever face.